And here's another if question, but again, with the tariff policy kind of changing week by week,
Yeah.
if the administration were to say, okay, this damage has been too great to our small businesses, to the market, et cetera, we're going to undo everything we've announced since Liberation Day. Would these suits go away, or would that weaken any of the cases? Or because one of the questions being considered is the specifics of IEPA, would they still proceed?
Well, there's a lot packed into that question. Certainly, if the government stands down and rescinds the IEPA-based tariffs, it would go a long way. It would certainly moot out any forward-looking complaint. Whether it moots the existing complaints depends on whether they also provide, whether they refund whatever tariffs have already been paid. And if they do that, then yes, that would be, I would expect the government to invoke the mootness doctrine that says, no harm anymore, so there's no reason for the court to get involved. And that wouldn't be, as a general matter, putting aside this particular administration, that wouldn't be unheard of, right? Government reconsiders actions all the time. But, time will tell whether this administration is going to reconsider its IEPA authority to set tariffs. So it really depends on what actions the government takes, how far back they rescind their actions.
It's highly hypothetical and
Highly
perhaps
hypothetical.
perhaps unlikely. One more prediction question for you. If the Supreme Court were to hear any one of these three cases tomorrow, how would you expect the nation's highest court to rule?
Well, good question, because this really brings to bear two different questions of administrative law that at least typically one would think this administration, being a conservative administration, is on the same side as the Supreme Court. But here they're not. And those two issues are deference to executive branch interpretations of statutes, which, now famously, we know from last year's decision in Loper-Bright overruling Chevron deference. Arguably, well, I wouldn't even say arguably, I would say doctrinally, the interpretation of IEPA is not one on which the court should defer to this administration. So that's a pure question of statutory interpretation. And as the Loper-Bright court articulated, that authority to interpret is vested entirely with the courts. So I would think, and so on that statutory question, I agree with the plaintiffs in these cases. There's nothing in IEPA that says anything about tariff setting authority. And it's also economically, an extraordinary step that the administration has taken. We might think of it as a major question under the major questions doctrine. So I think, those administrative law concepts that have garnered a lot of attention in recent years, I think cut against the White House. And then the second thing that cuts against the White House is the question of unconstitutional delegations of authority. I think that it's crystal clear that Article 1 of the Constitution vests with the Congress the authority to set tariffs. And there's no guardrails in IEPA that would even provide, what we think of as an intelligible principle under the existing non-delegation doctrine case law. That's what courts look for. Has Congress put in guardrails to at least, control what the president, how the extent to which the president exercises authority that is delegated. So even if we assume they've delegated something in IEPA, there's no guardrails here. So I think this administration's IEPA tariffs fail under the intelligible principle theory. And I think, even the intelligible principle as a theory of non-delegation doctrine is sort of, on the wane. And so point being, I think this White House is going to have trouble defending its actions, both on the statutory interpretation question and on the constitutional delegation question. So I think to your question, if the court were to hear if the Supreme Court were to hear this case tomorrow, I would favor the plaintiffs in the outcome.
I was just about to say the small business plaintiffs sound like they have the stronger case here, which leads me to my last question, perhaps some free legal advice for the small businesses watching, because of course Forbes reaches a lot of founders and small business owners. What would you say to a founder or business owner who's watching this, is feeling the impact of tariffs and considering legal action themselves?
Well, look, it's not my role to tell people to sue, but I think there are strong legal issues. And I think that if you have been damaged, if you've been harmed by these tariffs, or if you anticipate being harmed, then by all means, we have a legal system that exists to protect the interests of folks, who are being harmed by government action, and the courts are open. And people like me are also available to consult, because uh, that's these are important questions, and people should feel emboldened to exercise their rights and not sit on their rights.
Very important questions. Dan Wolff, thank you so, so much for your answers today. We appreciate your time and your analysis of the legal situation as it stands right now. We will have to have you back as these cases proceed through the courts. But in the meantime, thank you so much.
Happy to come back anytime. Thank you.